Welcome to Making Money with Laura Sanders, a name you can trust. With over 20 years of real estate experience and selling over 150 homes a year, Laura Sanders is the #1 RE/MAX agent in the state of Florida for 2021. Join us each week as we discuss how to make money through buying and flipping homes to renting versus selling and everything in between. To join the conversation, call in live 888-994-4995, Studio A.
Hi everyone, and welcome to Making Money with Laura Sanders, and I am your host, Laura Sanders. Every week we talk about something that will help you make a little money, save a little money, and this week we're going to talk about land leases. I am completely fascinated with land leases and how they work, whether it be a co-op, whether it be a single family home, whether it be a condo, and how that works, and whether or not you're going to lose your money with a land lease. So today we have Charles Esposito. He is one of the lawyers at JK Closings, and we're going to discuss today land leases. So welcome, Charles.
Thanks, Laura. Thanks for having me. I'm doing well. How are you?
Thank you for being here. I get so fascinated about land leases, and I'm always asking questions. And one of the things I always say about land leases, and maybe this is because, you know, I'm not 100 years old, but none of us have lived to 100, so we don't know what happens when land leases are typically like 99 years.
Right. Yeah, so with a land lease, and in Florida in particular, land leases were very common back in the 60s. And what would happen is a developer would lease the land to an association for 99 years. Land leases need to be at least 50 years for residential property, and they can be up to sometimes 120 years. And they're very interesting because not a lot of people realize, even if they're living on a property that has a land lease, they may not even realize it because the property can be sold multiple times while the original developer or the company that bought the property from the developer still has a land lease. And so now these places that have land leases that are 99 years old and they came into play in the 60s, they only have about 25 or 30 years left on them. And so we're starting to deal with properties that have land leases that are going to expire.
Right, and so I know that with a mortgage, they want to see 60 years or more left on the land lease.
That's right.
So I actually have a building right now where half of the building is owned by the building, and the other half is owned by somebody else who owns the land lease. That's weird.
That's very weird.
So I'm like, I told the president of the building, I'm like, you really need to figure out like how this is going to play out. Like, where's this going to go?
Right. And it's interesting because depending on when the building was built and when the lease came into effect, there could be different rules. So in 1977, there was a statute that was updated by the state of Florida, and it changed how land leases were going to work going forward, but it didn't modify all of the land leases that were in existence.
Okay.
So many land leases that are more current, they have buyout opportunities for the leaseholders. So the owners that you would think live there, that they have the actual opportunity to purchase the property. But if the land lease was put into place earlier than 1977, it's very possible that there's no opportunity for the actual members of the association who are living there to purchase it. And it depends on how each individual land lease was constructed and whether or not there's a reversion back to the developer or a right of refusal for the association members to actually purchase it. And if there is no ability in the lease, no mechanism in the lease for the members of the association to purchase the land, then they're at the mercy of the freeholder, which is like the landlord.
So if, let's just say it's a building, right? And there's 50 units in the building, and there's a land lease. What happens on that 100th year to all 50 units? They can just knock the building down and sell that land?
Yeah, the ownership interest will revert back to the freeholder if that's how the land lease was constructed in the beginning, which a lot of the older ones are like that.
And then you have nothing?
Then you have nothing. You have no equity stake in the property that you purchased.
And they don't give you anything for even the walls that sit in the building?
One of the benefits to the freeholder of doing a land lease is that all of the improvements made to the land run with the land too.
Let's be clear, a land lease here in Florida is going to be different than a land lease in New York.
It might be, yeah. And to talk to your point about lenders, you can't finance a property that's on a land lease unless there's a certain amount of time left.
Right.
So a lot of land leases now that have 25 to 30 years left on them, you can't even get a mortgage on because mortgages are 30 years. And so the bank wants to have the guarantee that the owner of the property, the owner of the unit or the owner of the single family home that they're actually financing is going to remain in that property throughout the duration of the mortgage. So if there's 25 or 30 years left on a land lease, you're not going to get financing on it. Similarly, we hear about recreation leases.
I was going to say,
lenders will not, they don't want to lend when there's a recreation lease. Those are also land leases, but they're a little bit different because they just have to do with recreational facilities.
So, okay, so interestingly enough, down in Hollywood, I did a building that had a rec lease, and it was for a pool, but the pool was like in the center of two buildings. Mm-hmm. So the rec lease was actually split between a building to the right and a building to the left, which is kind of weird.
Yeah, so it's almost like common area in that situation, and the developer created the recreational area, in this case a pool, and then they could have sold it to another party to end up being the landlord for that pool.
Right.
And then the buildings are paying a lease for
use the pool.
To use the pool.
Which
and
is
that's
ultimately
included
what
in
they
their
were
maintenance
doing.
fees and everything.
Right.
Yeah, and sometimes people do this, developers do this in order to make money over time, and then also to sell the interest in the pool. And then if it was built after 1977, there has to be a provision in that lease for the community to be able to purchase and buy out the actual
one building
rec area.
could. It's whichever building wants to decide to build it out, buy it out, right? Because there's two buildings there.
Yeah, it's possible, or it's possible that they could both buy it and then create it, make it a common area, turn it into like a condo common area type thing.
Okay. So yeah, that's why I say, because for some reason, like when a New Yorker comes here, they say to me all the time, well, we have co-ops and we don't have any issue getting a mortgage on a co-op. But here, it's almost like a dirty word.
Yeah, cooperatives here could be different than a cooperative the way that it's structured in New York, because cooperatives are very common in New York, but they may not be on land leases. The actual, cooperative may own the land itself, whereas down here, the cooperative could be leasing it from a freeholder. And if that's the case, then you run into those issues. So the cooperative doesn't have to be on a land lease, but it can be. And then there's also something with a cooperative called a proprietary lease. And if you don't have a proprietary lease with your cooperative, you can't get title insurance. It causes all sorts of issues.
What do you mean by proprietary lease?
Proprietary lease is essentially a lease between the cooperative and the freeholder as well, and the members of the cooperative. So if you don't have one of those in your cooperative, you can't get financing. And you can't get title insurance. Most cooperatives, you can't get financing unless you're putting like 50% down anyway. A lot of lenders don't want to finance a cooperative. But from a title insurance perspective, you can't get title insurance unless you have the proprietary lease.
Yeah, I have seen some lenders that do have some programs out there that will lend on these cooperatives, but obviously they're not conventional loans, So obviously realtors, when you're writing the contracts, you're not going to check off, conventional. You got to make sure that you're checking off other, because you want to be careful about that.
We always advise realtors whenever there's financing involved in the transaction, the lender is probably the most important person in the transaction. You've got to check with them to see whether or not the property is even financeable.
I know. I get a lot of realtors, they call me, they're like, oh, can you do FHA on this? And I'm like, how do they not know? Like, even like just looking at a property that has like letters in it, and I'm like, it's run by a condo. Like, how do they not know you? Like, there's like it's like a needle in a haystack to do FHA on a condo.
Yeah, and that's why it's really important to have an experienced realtor.
When you're hiring somebody, I mean, could you imagine packing your house up and getting ready to move and then find out that, oh, wrong kind of financing?
Yeah, and dealing with a lender that doesn't realize that they can't even finance the property as well. We're running into issues like that.
Yeah, crazy one was actually in Winmore. There was one of the buildings had written in there, so Freddie and Fannie won't lend on it. It's just one specific building.
Yes, I know the building that you're talking about.
And crazy enough, it's in the docs, right? Mm-hmm. The president didn't even know. So of course the president's like, oh, you can lend in here because there was a mistake made by a lender.
Yeah.
So they lent in there. And so of course when you go to look, you find that there's a mortgage been done, but then when you go back to the lender's like, yeah, we made a mistake. We can't even sell the loan, which that happens sometimes, mm-hmm. right?
Yeah.
So basically it says in there that if they were to foreclose, right, that they would be able to get paid first before the bank would be able to get paid their money. They would get their maintenance.
Right.
By them putting their maintenance ahead of the bank getting paid their money, the bank says, well, if you want to get paid first, we're not going to lend.
Right.
And that totally X'd out getting any mortgages in there.
Yeah.
And, you know, a lot of times when people say, oh, well, I'm sure the president knows. I'm like, you can't assume people know because this isn't what they do every day.
Right, exactly.
They're not
you can't assume that
lawyers,
anyone
yeah.
in the transaction knows. But
well, they're not even part of the transaction. They're just the president in the building. And
yeah, so you would think that the association is putting the realtors and the sellers on notice about this very important thing in terms of buying and selling property, which they may not be. You know, and going back to leaseholds, that happens with leaseholds all the time as well. And it's something that we don't necessarily see because leaseholds, you can get title insurance on them. So because a leasehold agreement allows for the leaseholders to sell the property, it's not a title issue. So when you sell a leasehold, you can get title insurance on it because it's subject to that lease agreement. So when we're reviewing title, we're not saying, oh, this property is uninsurable from a title insurance perspective because it is insurable. It's just subject to that lease. So if you're purchasing a property and nobody in the transaction knows that it's a lease,
right.
a leasehold agreement, your lender may not know it, your realtor may not know it, you as the buyer may not know it, and the seller may not know it because their payments might be wrapped into their monthly maintenance charges, or a really long time ago, the lease could have actually been paid for ahead of time in order to make the property more appetizing to buyers, basically.
okay.
So we may not even identify that as a title issue. And so we've had plenty of properties where people bought and then found out later that it's a leasehold estate. And they couldn't really do anything about it, and it expires in 40 or 50 years. You know, and I guess that property is going to be worth less in 40 years when it's going to revert back to the freeholder. But it's something that nobody in the transaction realized at the time of closing.
So what is, you know what, when we come back from break, I want to go to commercial, but when we come back from break, I want to find out what's like really the realtor's liability in selling a co-op to somebody, mm-hmm. to understand the liability that, hey, if there's only 25 years left and they pay cash, like, and there's no value in 25 years, what's our liability? So when we come back, let's talk about that. We'll be right back.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
At JK Closing Attorneys, we do all of the same things that a title company does, but with the benefits of being a law office. We can help with residential real estate, short sales, commercial real estate, refinances, 1031 exchanges, and FRIPTA withholding.
Contact JK Closing Attorneys today at 954-332-3111. Again, that is 954-332-3111.
You have been watching Making Money with Laura. For more information, contact Laura Sanders at 954-650-0827 or visit her website at theloracell.com. And now back to the show.
Hi everyone, and welcome back to Making Money with Laura Sanders, and I am your host, Laura Sanders. And we are talking about land leases and rec leases and what the liability is and do you lose your money, and you know, it's kind of crazy, and we have an amazing attorney here who knows so much about so many things, and he's kind of helping us kind of navigate this, because I get excited about this. I love talking about this stuff because, I mean, I don't even know how I didn't realize this as a kid that I like this stuff, but you know, I thought I wanted to be a therapist, and here I am, a realtor, and I really enjoy talking about this, and I'm not some 80-year-old dud, and I enjoy talking about these kind of things, understanding like for instance, what's the liability like for us? Like for me personally, and I have a client, and she'll probably listen to this, right? I said to her, I said, hey, listen, you're getting direct intercoastal. The worst case scenario is like you paid half the price that you would have paid to get this with value to it, but you got to live here for half the price. In the end, if they knock it down, and you got nothing.
Leasehold estate, you're not building the equity.
I said,
so normally cooperatives and other leaseholds, you know, if it is on a leasehold, is going to be less expensive than a condo that where the association owns the land outright. You know, so this is very similar to commercial investment property, where if you have a property, let's say there's a large commercial tenant inside a property, and you're selling it, and there's a cap rate. Well, the cap rate and the value of that property is highly dependent on how many years of that lease are left, because there's no guarantee that you're going to be able to renew the lease with the commercial tenant. So in a leasehold, there's no guarantee that the association is going to be able to buy the land outright or renew the lease at the same dollar amount that they have the lease for from back in the 60s. You know, and again, the law changed after 1977, so there's more protections for leaseholders, but we're talking about properties that have leases that are 99 years old and there's still 30 years of life left on them. If you're buying a property that's like that, there's a pretty good chance that you're not going to be able to renew that lease at the same dollar amount. The association's not going to be able to renew it at the same dollar amount, or purchase the land outright. So you might be buying into a property that's not going to have any equity in 30 years and not be worth anything in 30 years. So maybe right now, today in 2024, it's not that big of a deal, because very rarely do people buy, especially a condo or a co-op, you know, to live in for the next 30 years. Most people buy property and then sell it within 7 to 10 years if it's their primary residence. And if it's less, if it's an investment property, you know, but when there's 10 years of life left on that lease, what's that property going to be worth? You know,
so
maybe not that much.
I guess that's the other question. Like, would it be worth it to buy a bunch of these like co-ops when it comes down to it and play Russian roulette with it? Like, I don't know. Like,
there are some, you know, developers, and there are some investors that try to buy up as many in one building or one association that they can, and then try to renegotiate the lease with the freeholder. So it's possible, but you don't know. You don't know what the freeholder wants to do. A lot of this land that wasn't so valuable in the 60s is now way more valuable. Obviously, with inflation and with all the people moving to Florida, they may want to find a new developer to develop new buildings, and you know, they can extinguish what's on that land.
I think the one with the owning half of the land and then the other half's owned by some, I think that's going to be an interesting, that's going to be really interesting.
Yeah, and those of you that are used to dealing with condo associations and HOA associations, imagine two associations having to fight over a pool and having to come to an agreement over that. You know, I know one of our properties, there's 2 condos and they split the parking lot, you know, and they can never come to an agreement on, painting the parking spaces and putting numbers on them and all sorts of things like that. So when you get into arguments and disputes with associations, everything tends to be a lot more difficult. And like you said, with the board president in that building, they didn't know what the rules were. Some of these people, obviously, most of them were not living there in the 60s. They're not going to necessarily know what the ins and outs of these leases are. And, they were going to have to hire an attorney to figure that out. And then they're spending money on legal fees and disputes and things like that. So you do have to be very careful about what type of property are you buying and what's the actual, who's the actual title holder on it? Is it a leasehold? And if it is, you need to know how many years are left on that lease.
And that's interesting. And I wonder what realtors are telling people when they send them these properties. Like, what are they telling them? And what should they be telling them?
Certainly, if the realtor knows that it's a leasehold, they should be disclosing that to a potential buyer. And the seller should as well. A lot of times we find out that the realtors don't know that it's a leasehold. And they either find out during the course of the transaction from the association, or they find out, maybe we discover that, which is possible. We discover these things a lot, especially if it's financed. If it's a cash transaction, though, there are times when nobody discovers that it's an actual leasehold because it's not really a title issue. You're getting clear title when you buy a leasehold property. We're assuming that everybody involved in the transaction already knows that as well.
But you're pointing it out anyway, just
right.
because.
We might be pointing it out if it's something, but we may not even realize it because some of these fees for the leases are not actually broken down. The association has combined the lease fee in with their annual maintenance fee. And so when we see the numbers that are coming from the association, it's not separated. And if they don't separate that for us, we don't notice that at closing.
Why wouldn't they separate it, though? Don't you think that's something that should be disclosed that way?
It absolutely should be disclosed. You should know the difference between a maintenance fee and a lease fee.
Century Village has like 3 different fees.
Yeah, they have 3 different associations in most of the Century Villages.
Yeah, they have like the Century Village, then they have like the actual building maintenance, and then they have the rec fee, which has created a financing issue.
Yeah, recreational leases create financing issues because they are leaseholds, just like regular leaseholds create the financing issues. So if you do have a lender on a transaction, I even recommend for cash transactions to have your preferred lender take a look at the financials from the association to determine whether or not it's financeable. Certainly if you're buying a unit in a cooperative or a condo or even a regular HOA, if it's not financeable, when you go to sell it and it's still not financeable, that property's worth less than another comparable unit that is financeable.
Which is something that I try to point out to appraisers when I meet the appraisers.
So last time I was on, we were talking about the condo law. So
Right.
3 stories or higher, January 1st, they're going to have fully funded reserves. So all condos, cooperatives, 3-story buildings are going to have fully funded reserves. And starting January 1st, we're going to start to get more inspections from municipalities and from the state to determine whether or not these places are in compliance. So another reason why we want to have lenders look at our budgets and our association financials is to look to see at what stage these associations are at with that new law in mind. Because when the law was passed, something like 75% of associations did not have fully funded reserves. So over the last couple of years, we've seen special assessments, we've seen higher maintenance fees to come into compliance with that law. We're seeing 25-year milestone inspections, 30-year milestone inspections. Every 10 years they have to have a milestone inspection, and if you're closer to the water within 3 miles, you have to do it within 25 years. Wow. So buildings that were built in the year 2000, next year, if they're within 3 miles of the water and they're 3 stories or higher, they're going to have a 25-year milestone inspection, and that's going to lead to issues.
Okay. So we've got that coming up, and then we're running out of time, but then we have what's coming up July 1st.
Yeah, with the NAR settlement, we're going to see changes to the Florida as-is contract, listing agreements, buyer-broker agreements, so we want to be on the lookout for that. Certainly as realtors, that's going to change the landscape a little bit, and we're going to be doing trainings on that. I'm sure we'll talk about it more as the settlement agreement is most likely going to get passed. It could still change at this stage, so we don't want to speculate too much, but things are going to change. The MLS is going to change. and everyone needs to be prepared for that, needs to understand how to explain that to buyers and sellers.
So you're going to be doing some training. So if you're a realtor and you want to get some training on this, what's the best way for them to reach out to find out when your trainings are going to be?
Yeah, we have a special Facebook group for realtors. You can look for us there, JK Closings, Events and Trainings. Phone numbers 954-779-5000. Shoot us a text. We'll add you to our list, and we're going to be doing some trainings on this in the near future.
Yeah, and they do a great job. They have they're fully staffed for closings, and they're always available for any of your needs to either represent your sellers or for your buyers. So, and if you're looking for the best realtor out there, you should definitely give me a call, Laura Sanders, 954-650-0827, and make it a great night. And until next week, see you then. Bye.
Thank you for tuning in for Making Money with Laura Sanders, a name you can trust. To join the conversation, call us at the studio, 888-994-4995 Studio A, or contact Laura directly at 954-650-0827. Laura Sanders, a name you can trust. We look forward to seeing you next week.